All right, we're going to make the best use of our time as we possibly can today. So today's listening session is exclusively focused on the 10% tax motion passed by General Counsel on July 4th, 2025. We'll have a hard break. I know it was intended to be 1 p.m. We may go a couple minutes past, but we do have a way in order for tribal members to get additional questions in that I'll announce later. The DDA meeting starts at 1:30. For those in the room, everybody is invited to stay for that. So let's start by reading through and going back and reviewing the actual motion that was passed July 4th. And then we'll go through the very brief FAQ that's been posted out on the tribal website and official media sites. So the motion that was passed on July 4th was to authorize the Quapaw Nation Tax Commission to tax our casinos at 10% and for that to be paid to all tribal members 18 and above as a gift the first week of December annually. So we'll just go through the Q&A document. The first question is, will tribal members receive a check in December of 2025? No, it would be a violation of federal law. Question 2, why will tribal members not receive a check December of 2025? The Indian Gaming Regulatory Act, IGRA, has rules for when a tribe makes per capita payments of net gaming revenue to tribal members. Question 3, what are the rules for making per capita payments to tribal members? It requires a revenue allocation plan, commonly referred to as a RAP, be submitted to the Department of Interior's Office of Indian Gaming and approval by the Assistant Secretary, Indian Affairs. Question 4, what is a RAP? It's a document submitted by an Indian tribe that provides for the distribution of net gaming revenue when it intends to make per capita payments to its members from its net gaming revenues. Question 5, does the Quapaw Nation have an approved RAP? No. Question 6, why does the Quapaw Nation not have an approved RAP? Because the Quapaw Nation has not made per capita payments from its net gaming revenues to its members in the past. Question 7, why is this different than the social services tribal members are eligible for today, such as utility assistance, veterans assistance, unmet needs, etc.? The Quapaw Nation's current social services are lawfully funded by net gaming revenue pursuant to the Tribal General Welfare Exclusion Act of 2014. The General Welfare Exclusion Act of 2014 is a federal law that allows tribes to provide reasonable cost of living payments to tribal members. And according to the Internal Revenue Service, these payments are non-taxable income if they are provided pursuant to a specific tribal program and are not lavish or extravagant. That's why the current social services are not taxable income to tribal members who receive the service or assistance. Question 8, the motion was to provide a gift. Why is that not permissible? Per the NIGC's use of net gaming revenue bulletin, and this is from some time ago, but it still holds true from 2005, there are multiple federal court cases that ruled against tribal nations where one of the judges actually stated, just as a rose by any other name is still a rose, a per capita payment by any other name is still a per capita payment. Question 9, the motion excluded tribal members below the age of 18. Is that allowed in a RAP? Per the NIGC, if tribes choose to make per capita payments to individual members, they must be made to all enrolled members unless there is a reasonable justification for limiting payments to a group of enrolled members and excluding the remaining enrolled members. In addition, a RAP must protect the interests of minors and incompetent members of the tribe. Question 10, why did the attorneys present July 4th, 2025 not explain this at the time the motion was made? During General Counsel meetings, they serve solely in an advisory role as the parliamentarian and do not have the authority to overrule motions or restrict members' right to speak. Then there's a reference to the Robert's Rules of Order. The attorney's legal review of actions taken during the meeting occurs after the meeting. Question 11, can we prepare a RAP? Why, yes. That's the purpose of the upcoming town hall meetings. In those meetings, additional details will be reviewed on the requirements, limits, beliefs, and values and outcomes the Quapaw Nation wishes to be included in our RAP. A listening session will be held, obviously today, at the community building, and then we will, take questions, and then we endeavor to answer all of those questions for all tribal members in writing after this meeting, as well as in subsequent town hall meetings. So how long will that wrap take? That is unknown. However, the greater the tribal member participation, the better the wrap will reflect Quapaw Nation values. Question 13. Once the wrap is finalized, how long does the approval process take? Department of Interior approvals are estimated to take 6 to 12 months. Question 14. Once the wrap is approved, will it become effective going forward only, or will it be retroactive to December of 2025? The wrap becomes effective going forward only. Question 15. Are there other constraints on how much can be distributed per capita? Yes. There are several other constraints, and they include 3 things. 1, continued compliance with our debt covenants, including the fixed coverage charge ratio and the leverage ratios. 2, sufficient unencumbered funds available for distribution beyond the level required to fund tribal government, provide for general welfare of the tribe, promote economic development, donate to charitable organizations, and help fund operation of local government. 3, per capita distributions of net gaming revenue cannot exceed 50%. Otherwise, it triggers additional scrutiny. Question 16. Are per capita distributions taxable income to individual tribal members? Yes, they are. Question 17. Are social services and programs treated as taxable income to individual tribal members if deemed under the general welfare exclusion? No, they are not. Question 18. Is Saracen Casino and Resort subject to a wrap? No. Saracen Casino and Resort is a commercial casino, is not subject to the Indian Gaming Regulatory Act, and therefore no wrap is necessary. Question 19. Why can we not distribute Saracen Casino and Resort's net gaming revenue? 100% of Saracen Casino and Resort's net gaming revenue generated to date has been reinvested into the property. Once the hotel and event center are complete and enough of the outstanding debt is repaid, SCR can begin making tribal distributions in the future, subject to continued compliance with the debt covenants. Please see the memo that was published October the 2nd, 2025, available on the tribal website, regarding implications of the 10% tax by Quapaw Nation on gaming properties for further analysis. So to get us started, Member Davis will now read through questions on the topic that we've already received to tribal members, just to get us rolling. Thank you, Member Davis.
Oh, thank you, Madam Chair. Just thank you all for being here today. And as we go through this process, like Madam Chair said, that these are some of the questions that have been gathered already, just to kind of not create duplication if this might be the same question that you have. If we vote yes, will that let the government take away a lot of the tribal benefits? Effective date and payout year. Does the proposed change begin this December 2025, or is it intended to take effect in December 2026? Specifically, in which calendar year should tribal members expect payouts or commission adjustments to be reflected? Retroactive application and scope. If the motion is intended to apply to the current year 2025, will the 10% commission be retroactively applied to payouts already made? If so, please specify the exact start date used to calculate retroactive adjustments, for example, January 1, 2025, July 4th, 2025, or another date. Whether tribal members should expect repayment requests adjusted for future disbursements or other corrective actions. How the nation plans to communicate and implement these adjustments to ensure fairness and transparency. Public documentation and communication. Will the Business Committee commit to publishing a clear summary of the final decision, including effective dates, payout timelines, and retroactive scope, on the nation's website or via official communication channels immediately following the meeting? Will the 10% tax apply to all Quapaw-owned casinos, including Saracen in Arkansas? Is the tax based on gross or net revenue? Status on the 10% tax motion. Please confirm whether the motion has been adopted, deferred, or modified. If deferred, what is the timeline and process for reconsideration? Voting process and member rights. Will tribal members have the opportunity to vote on this motion in a future general council or other formal setting? If not, please explain the rationale and legal basis for bypassing a vote on a motion that directly affects member distributions. And again, I just want to emphasize that these are questions that the Business Committee has already received from inquiries from Quapaw tribal citizens. Gonna gay.
Thank you, Member Davis. Remember, today's session is about listening, really listening to your questions. We do not expect to answer questions today, especially since time is running short. Our goal is to document all of your questions and provide answers in writing to all tribal members, whether they're present in person today or on Zoom. We welcome additional tribal member questions now. Please use the microphone so those on Zoom and even those in the room can hear your questions, and we want your questions to be heard.
My question is this. We voted on that 4th of July. You guys didn't bother to let us know anything about that until just not too long ago. Everybody went all those months thinking that we were going to get that 10% payment. There's a whole lot of people out there that were awfully disappointed. If I was out working in the field and I had you as my employee, I would have fired you for not telling me something and holding it back all that time. You never told any of us that this wasn't going to happen. We voted on that, and we deserve to know sooner than months down the road.
Thank you.
I just want to know, how does this not, how can you not see all of us out here and that we voted on it and expect us to talk to you in 30 minutes? I mean, you're giving us 30 minutes to talk to you, and then you're going to have another meeting? Am I right?
That is correct. So that we
30
can
minutes?
provide feedback.
So you can, so 30 minutes we're supposed to provide or so we can talk to you.
So any additional questions that we may not have time to address or to collect today, I would ask that those questions be sent to business.committee@quapawnation.com so that we can get a whole inventory and provide feedback to all tribal members.
How is that? We can't even get a lawyer for them. Excuse me, I ask a question.
The purpose here is to get the questions out on the table, and so that we can provide good feedback. We want to be able to address all those questions in some upcoming town halls as we begin to define and draft what that revenue allocation plan should indeed look like.
Oh, so it's all on your time. All on Winna's time.
I don't think.
I realize that you guys are under Robert's Rules of Orders, but the General Assembly, everybody that shows up at the meetings on the 4th of July are the ones that actually do the voting, correct?
That is correct.
Okay, so it didn't have to be put on the agenda, did it not? That this vote was to be taken.
I'm not sure I understand your question, Vicki, but this particular motion on July the 4th was put forward. It was not on the agenda. That was done as a part of open forum motions, if I recall correctly.
So does that count or not? Because it was passed, correct?
Yes, ma'am. It was
So-
indeed.
Does it count or not?
Yes, it does. Unfortunately, we're not saying no. We're saying not yet. And that's what the purpose of the town halls are going to be as
Here's
we go
my
through
next
time.
question, follow up. How did the attorneys that BC has on retainer manage to come up with a reply, instantaneous reply, because I think it was just a day or two after they were on Facebook with this paper, which I found really strange that it was not signed by any of the business committee, and it was not dated. It was not even signed by the attorneys. And I, for one, am not going to have a white man tell me how to run my tribe.
So, Vicky, are you saying there was a resolution that was never executed by anyone? It passed in general council.
Was that legal or not?
Well, no, it was not. That was the memo that was published in the very beginning of October.
Well, then how did the attorneys jump on it so fast?
Well, that was October because they had to take some time to perform analysis based on the motion that was put forward.
Why didn't you guys catch it if it wasn't a legal motion?
We didn't know that at the time. Or actually, we didn't know how we were going to go about doing it.
I can tell you this, during the meeting, I was in the process of trying to table that question when the call for question was called. Once according to Robert's Rules of Order, once call for the question is called, all other discussions cease. And because it was called so fast and it immediately went to the vote. So attempts to table it, attempts to have any other conversations about it. Once it said, somebody said, call for the question, everything ceases, it goes to vote.
But that
Regardless as to whether it was a valid vote or a valid motion or not.
That just pertains to the BC, correct?
No, that pertains to everyone within general council because the general council meeting is general council's meeting. It's not the business committee meetings. The meetings that we have monthly here are the business committee meetings where we have the conversations. It's the meeting for those monthly meetings are meetings for us.
Well,
And
I'm
we
still trying to
run
wrap
it
my head
that way. But
around-
general council we can direct it, but it's not, it can't be, we don't control it. General council controls the general council meeting.
I'm trying to wrap my head around how the business committee, the BC, is governed by Robert's Rules of Order, which means you can have your little attorneys up there, your marshals and what have you. You can do all that. How much money overall was saved in canceling that special business committee meeting? Because on Facebook it stated trying to save money by canceling the special general council. How much money was saved?
Somewhere in the neighborhood of about, depending upon how many people were in the room, about 20 to 30,000.
Okay.
I think a number of people had their hands up.
When we get the per cap, will that cut back on the social services?
Well, we don't know because that's going to be dependent upon what we determine in the town halls. One example that was brought forward by a DDA member of another neighboring tribe, they do something pretty interesting, and that is they give tribal members an option between choosing social services like our utility assistance, those kinds of things, under the general welfare exclusion, or they get a per capita. The cool thing about general welfare exclusion services is they're non-taxable versus per capita payments are indeed taxable to the individual tribal member, and they would have to pay both federal as well as state taxes on it if they live in a state that has an income tax. We thought that was pretty interesting.
Okay. Some explanation here. We were told with the Gaming Commission and with a lot of these things, I don't know where Woodman, whoever these, Drummond Woodson came from, but I was told originally the business committee announced that they had attorneys that covered all facets of government. Well, they don't have a good gaming attorney. The gaming attorney that the first general council, the first gaming commission had, was removed by the gaming commission, and one that was put in place that knew nothing about gaming, he does now because the gaming commission has trained him, or partly. But the Giles was the first gaming commission's attorney. He was the one that was at the meeting when the motion was made. Those of us that know gaming and know what the rules are knew that the motion was out of place and that it was illegal, but it went ahead and got passed. And at that point in time, that attorney should have informed you that it was illegal, so you could have done something about it before October. That was from July till October. They didn't have to look into it for any reason because it was illegal from the get-go. And probably the person that made the motion knew that too. I'm not saying because I don't really know, but proof's not there. If people need to know that if the money's not there out of the net profits from gaming for a per capita, I hate that word, payment is made, even if it's $25,000, a one-time payment of just say $25,000. Look at what you get now that's not taxable. A $5,000 health card, utilities for whatever age category you're in, education money, veteran money, assistance for emergency, all of these things that we are supplied now from gaming money, that could go away. Now, the first I've heard where you just said that it could work both ways. I've never heard that before. If you get a per capita payment, well, which you were saying, as I understand it, they could take either or. So if you took either or, then down the road, when people continue, depending upon how long you live, if you continue to get the services of your tribe, of your nation, such as they are, if they would continue, then you would get much more than $25,000. So you've got to remember that just because a bird in the hand might not be the bird in the bush down the line, per capita payments are not what they appear to be oftentimes, a one-time glory hallelujah payment. So, but I disagree with you saying that the legal counsel could not have afforded us or told you that very day, if he was supposed to be the gaming attorney, he should have known that that was illegal and that it couldn't have happened. Now, it did happen very fast. I agree with that. The vote was called for very fast, which may have prevented Linda from giving her tabling claim. But there's really no excuse for this firm. I am so against this. Just my opinion. So against this firm that we pay them $55,000 a month, what I'm told, and they're supposed to be able to cover everything. When about the only thing they really are specific in covering is the business committee business, because you all tell them what you want them to do, and they don't have gaming experience, they don't have ethics experience, they don't have probably legal martial experience. I really think that it's false that we can't hire specific lawyers. Like at $250 an hour is pennies compared to most lawyer fees, and that we can't just pay specific lawyers per hour, not over a month, not a month at a time, to do what we need them to do each time at an hourly wage. Thank you.
Thank you, Barbara.
Just to clarify too, and I think my time on the Constitution here for this, but after the call for question is called, you can actually point of order any question. Because especially if it's an illegal question, point of order, boom, it's dead on arrival.
I'm sorry, I probably should have done that, but I was not aware that I could do that at that moment.
Well, as you said, though, Secretary Treasurer, it's not your meeting; it's the business of the General Counsel, right? Which the chair had that, opportunity to do that in your stead. I wanted to ask a question about this document that we're relying on so heavily as getting answered questions. Question 10 talks about the extent of the parliamentarians' responsibilities. And do you know who wrote that? Is this something put forward by the attorneys?
No, I wrote it initially, and then the attorneys included the Robert's Rule of Order references.
I've spoken on this a couple of times, and that's about selective presentation, especially from our key dignitary doing it multiple times. And, you know, something that's conveniently been left out of that question 10 is that during a meeting, the work of the parliamentarian should be limited to giving advice to the chair and, when requested, to any other member. It is also the duty of the parliamentarian, as inconspicuously as possible, to call the attention of the chair to any error in the proceedings that may affect the substantiative rights of any member or may otherwise do harm. We're looking at a whole lot of harm. We're looking at the result of that attorney not inconspicuously getting the chair's attention. And as a result, we have so much commotion over this, and you know, a lot of us are here from out of town, and you know, it's unnecessary to have gotten this far. But going back to the selective presentation of information, this is not transparency. This is telling us what you want to say so that you look good. Like, we would do a whole lot better if you just said, look, we dropped the ball, man. Like, we messed up and we want to make it right, so here's what we need to do. Like, I trust that person more than I trust somebody presenting something half-assed here. Sorry. Presenting half the information here. And if Drummond Woodsum does not have the ability, this is multiple times, you all know that this is multiple times that they've dropped the ball. They should not be our parliamentarian governing our most precious body of creating legislation. General counsel, they do not belong there. Multiple times they have done this.
To focus on what was happening in July was the fact that, again, we've heard such glowing reports of how well we're doing, and that it came up, well, what about the quality of life of your people? There's need out there, and that was mentioned, that we do have needs, and that's why it was brought up. Why couldn't we have some of those riches? And that's why, again, it was presented. There was a motion. It was seconded. And my thought is, again, there's more than one way to do something. This is what the people want.
And that's what we want to do.
Quick question. It's me again. Why didn't your attorneys, the BC's attorneys, respond quicker than what they did? Whether it's saying this motion didn't comply with Robert's Rules of Order, why didn't they jump in, your parliamentarian, who we cannot stand? But you let it go through, because otherwise that picture showing where it passed, and you admitted it passed. The picture showed, and then after that you could have said that's an illegal motion. We should not have never voted on it. Why wait all this time?
And to be honest with you, Vicki, I agree with you, and I have to take responsibility for that. Is that the individual that's
It's
presiding
seven of
over
us.
the meeting? I know.
It's
but-
all of us that deserve the heat from this. So, and I don't have the gaming background or experience, but our attorneys should know. But at the time, didn't seem like I guess, time to rule on that. I don't know. So.
And I have to say for myself, it actually, that kind of emotion, it threw me for a loop. I was completely confused by whether it would be legal or not. And
Well,
I wanted
Fran-
to make sure that we were doing all of our due diligence to make sure we had everything accurate and correct, and that we're doing all of this properly, and that we're doing it legally. So I wanted to be able to take the time to do the research, whether it's asking the attorneys to give us some advice on this, or finding things on my own, reading up on some stuff, and making sure that what I was interpreting with some of these other legal statutes and stuff, especially with NIGC and IGRA and federal tax law, all of that stuff, to be able to research, take that time to research it, and make sure that what we come back to you with is accurate.
Well, that's
So-
all
and
good
it
and
does take time.
fine. But who put together this? Who responded to this?
I
Business
drafted
committee?
the FAQ, Vicky.
And we all reviewed it, and if there was
Well,
anything
why
else that we
wasn't
wanted
it
to add,
signed
then
by the
it's all on all
business
of us.
committee, or why wasn't it dated by the business committee?
Never dawned, honestly, Vicky, it
Yeah,
never
we
dawned on
didn't-
me
Right.
to both sign it as well as put a date on it.
Why isn't there a policy and procedure for the general counsel to follow when we have these special meetings? Why cancel it at the last minute after I have family that's calling me left and right saying, okay, I switched with somebody at work to be able to come up, and now you're telling me it's canceled? Who
Fair point,
reimbursed,
Vicky. Fair
who
point.
reimbursed everybody?
No reimbursements have been provided. We verified at the time we were canceling the special GC that any food that had been ordered would be utilized there at Downstream to no charge to, the tribe. But as far as I'm aware, maybe you guys do, I'm not aware of any travel reimbursements for anyone, Vicky.
And now you wonder why people don't attend general council?
Well, that's never the goal, to decrease participation in general council meetings, but you're making a very valid and fair point, Vicky.
On behalf of what you're saying, until the Gaming Commission and the DDA and the Business Committee met a couple of weeks ago, I was unaware of the status. I knew it was different for the Saracen loans and bonds, and as it was explained, but here again, transparency of the Business Committee to the General Counsel would help your case so much if things like that were explained like they were. If people stick around, I don't know what the DDA meeting is going to cover today, but for the explanation of how these monies are appropriated and brought to, the loans are made to the tribe and to pay back, there's stipulations for, thousands of them that have to be met. That Saracens was, I knew it was made different, and I knew it was made just exactly like one individual wanted it to be made. But it cannot be touched. The money can't be touched, they explained, the DDA explained, for any reason until it's paid off, if I understood him right. And they showed all the figures and facts, and they are making money. They're making a lot of money and have the opportunity because Arkansas laws pertaining to gaming are a lot different than Oklahoma's. So probably the most money will be made in Arkansas, currently anyway, until some of the other debts are paid off here. So that was made very clear to us. And maybe people would understand more about why this can't be done if it was explained why it can't be done, instead of just saying, no, you can't have a payment, or no, we're not going to be able to do that. Because it is easy to understand. If you make it understandable, it will be easy for all the individuals in the general council to understand why it couldn't be done and why it was illegal. So that's just my take on it. I think if people know and can be made to understand why it can't happen at this time, then there won't be this big issue. Maybe.
That's a good comment, Barbara. I know that the DDA has committed to doing that very thing in one of the upcoming town halls when we discuss this.
Madam Chair, may I just ask the audience a question? Can anybody tell me 10% of what?
Gaming revenue as it's come in before.
There wasn't,
But
it
there's
wasn't in the motion, so is it net gaming revenue? Gross gaming revenue? Is it alcoholic revenue? Is it,
Is it from the games? Is it from slots? Is it from hotel? And there's a lot of other questions in there. I think we
you're
do
all
have
just
some-
assuming where it's coming from. We don't know where it was coming from.
I think Sean said.
So I know we're going to have, I apologize for doing this. I know it's 1:21. The DDA meeting needs to start at 1:30. There are a couple of items. I think, Linda Valier, your eyesight
I
is
can
better
see-
than
I
mine. You can see
the
chat
number in the
box.
chat. So if there's anybody in chat that has questions, because
We just want to make sure that they get recorded. Okay.
okay,
I just wanted to make I don't really have a question. I just wanted to make a remark that even though I voted yes at General Council, which I did not for 1 second believe that it was going to be coming because I've never heard of anything like this before. But I still voted yes in hopes of it might happen. But I'm just saying, I think that you guys are in a predicament because of the way you handled it. It comes down to that. You know, you could put this back on Sean Matthews because he's the one that, presented it, but you guys are the ones that didn't step up and say, whoa, wait a minute. I not even commit to not paying it, but just commit to saying, well, look into this, So, you quietly went out the room like the rest of us, and this thing's just been quietly festering. And I knew that it was going to resurface come December because people are going to expect that check in the mail. So it's not a good reflection on our attorney, but it is what it is. So I think just the secret here is just to inform the people. Try to do better.
Thank you, Betty.
Thank you.
Appreciate it.
I think one thing that people are looking at is we've had Downstream has been open since 2007. So that's 18 years. And I know it was supposed to have been paid off in 5 years, and we all know why it wasn't. We know that there was money confiscated and everything, but how that was handled. But what are we doing now? At the moment, what are we doing now to try to get it paid down? Is the DDA, I know the business committee aren't supposed to be over the casinos. So is the DDA looking at various things like salaries? I know that salaries have went up 35 to 40% since I was there 5 years ago. And that's just ridiculous. I mean, you need to look at the top down. The lower people are not getting it, but the top people are. You've got 5 people in upper management and marketing right now. When I was there for 12 years, we had a manager mainly. We had different directors over various periods of time in the first 3 or 4 years. But I really think if we could get this paid down even more, if they would look at what we're doing with our money. I think the DDA needs to really delve into this basically from the top down.
So similar comment on Downstream is what I shared based on Barbara's question on Saracen. The DDA is diligently looking at those things, and they're going to be showing in one of the upcoming town halls more details about how they're approaching the paying off the remaining debt on Downstream. And they absolutely look at those numbers carefully.
But if they look at the salaries, I'd really appreciate it.
One last question, and then we're going to have to close. Go ahead, Vicki. Oh, hold on, Johnny's, yeah.
Okay, is this BC following the intent or the letter of the law?
We're trying to follow the letter of the law.
Well, shouldn't you be factoring in the intent, what the original people thought about in 1956?
No, I understand. I think I understand what you're saying, Vicky, and you're absolutely right, because the intent of general counsel was to make distributions to tribal members. And we're not saying, no, we're not going to do that. We're saying, let us figure out how we're going to be able to do that legally and rightfully and do it the right way.
Okay, and my last question is, why is it none of you that knew me and visited with me and all that kind of good stuff, when you were running for office, nobody's been coming around?
Good question. Thank you, Vicky. All right, we're going to go ahead and close out the listening session. For those who think of additional questions after this particular time together, please feel free to send those questions on to business.committee@quapawnation.com. And then we're going to flip over to the DDA meeting. Thanks, y'all.